and save the applause till the end. If you like the presentation, then it will work. I understand I have to be close to this thing right here, so everyone that is not here can listen to me, and we'll see how it works. Okay. Good morning, everyone. I'm really excited. I'm very honored to be here once again. This is my second time visiting this lovely university. Actually, I was invited once again to teach basically, the same, not the same, but related matters to legal English that at the time, this was 2 years ago, it was also very important for that program that was being taught to include this legal English matters. A little bit about myself. I'm actually an in-house counsel. I work for a company. I've been working there for almost 20 years. I have my experience also in some law firms as well, with a very, let's say, clear inclination to corporate law. However, around 8 years ago, I started out, I always have loved academics, right? I always like books, and as I'm sure you do. And 8 years ago, I was invited to start out to teach a class in Tech, Monterrey, which is my alma mater. And all started out like a simple, let's say, invitation for a couple of weeks, and then started out for a semester, and then 1 year, and then 8 years, and then COVID hit. And I decided to stop for a year, and throughout that year, I've been doing this type of sessions, right? Phi Delta Phi with different chapters. I am Phi Delta Phi myself. I was invited to be an honor member almost like a couple of years ago, perhaps. So anyway, enough about me. This legal English course, which basically on its term, I haven't really get a sense of it. What does legal English mean? Doesn't mean anything, really. Don't be surprised. Legal English, it's basically a course that it's taught in American universities for foreigners or foreign students coming from other countries. And it basically tries to capture in a very, let's say, compact amount of time, different types of topics, such as constitutional law, contractual law, torts law, civil procedure, which it's another word for litigation, environmental law, the big topics, let's say. And this is how many years ago, American universities started out providing this course to try to give, again, a broad perspective of the American legal system. Of course, this is now replicated in some other universities throughout the world to produce that same perspective on that specific country legal system. I believe that, for instance, when Mexico receives foreign students, there's also some sort of class that provides like a broad picture of the Mexican legal system for foreign students, right? I believe there's one, and of course it's not called legal English, perhaps Mexican law or something like that. But anyway, so all of that just to give you like a sense of what does legal English means. And of course, this is going to be concentrated in American law. The two topics that I like the most, even though there's more, it's constitutional law and contractual law. Constitutional law provides like a broad sense of how the legal system works there, from a broad perspective. And contractual law, which is going to be covered next session, well, it's law that deals with contracts, basically, and promises and offers and whatnot. I must say that this session, constitutional law, it's a little bit more on the theory side, and the contractual law is more on the pragmatic side. And I know some of you might say I'm more inclined to theory, and I love that. And some others might say I don't like theory, and I want to make money out of this, right? I understand that. I like pragmatic things. That's usually guys, right? Yes. I understand that. But please try to capture these sessions as something that can somehow contribute to your own legal culture, right? That's basically it. And my purpose today and within the following sessions would be, I'm sorry for the cliche, right? But just to try to plant some sort of seed within you and might capture curiosity throughout throughout your next years as lawyers, right? For me, this type of topics never captured me while I was young. This type of topics began to capture me when I was already working. And my first boss in that firm, the first small little firm that I worked for, was a guy that loved this type of topics and information and being very well documented and read in books, etc. I started out late, and I believe that was one of my first steps to move forward in terms of that, starting teaching that class that I referred before, which is, by the way, called Legal English. Because I wanted to share what I captured late in my life. I wanted to share that with young people like you, for you to start earning. Okay? That's it. Now we can leave. Okay. Sorry. I haven't had any coffee, so my brain is still not connected. We'll get there.
Do you want the coffee? Sorry.
I would love that, yes.
Okay.
But somebody told me that it's being prepared. If it's ready, that'll be great. Thank you. So another thing, these sessions are for you, not for me. And you're going to say, well, of course, we know that. We pay for these sessions. Yes, I understand that. And I'm sure you know this. But this is, I'm here for you. You need to ask whatever thing comes into your mind and comment whatever thing comes into your mind and interrupt me as many times as you like, because this is for you. If after these sessions that we're going to have, you are the same people when you leave, then the same people that when you came in, this is useless. You're supposed to be somebody different when this finishes. And I'm not saying this is going to be an enlightening, right? Of course. No, I'm not saying that. But please take something out of it, right? Or take a little, use those, right? Concentrate on that. I'm going to try to give you something to be somebody else by the time we finish those courses. By the way, people watching at home or whatever you are, hello, welcome as well. If for some reason, this is more into the mechanics of the course, if for some reason you think that you have like an encouragement to make a question, if you don't feel completely comfortable doing it in English, do it in Spanish. I don't care. It will be great if it's in English because we can practice it, and that's part of this, right? But I'm also interested that you convey your ideas. And if you find that to be more comfortable doing it in Spanish, let's do so. All right? I see some faces that I might recognize. By the way, I'm not using a mask because I'm far away from you and I'm vaccinated already. So, okay. But I see some familiar faces. Perhaps some of you already took the course 3 years ago? No? Yes. Oh, you, of course. Axel, yes. No one else? No, you. All right. You were here. Good. All right. So let's begin. I believe somebody was going to help me out with the presentation. Let's start. Any questions? Oh, by the way, I would like, this is a long session, right? 3-hour session. So I would like, if that's okay with you, to make a small break, half of it, 10 minutes around that. Have a sip of coffee and whatnot. And then restart. Is that okay with you? Good. Is people at home being able to listen to me? I don't know. Our tech guys themselves. Okay, he's busy. Can we start? Good. Hello. Thank you. So, as I was trying to say before, the purpose of this course, it's basically to raise your intellectual curiosity, right? That, for me, it's fine. It is fine. Feed your legal culture. Try to learn a little bit more than you already know. Sometimes, and I understand that you're in the top semesters. I understand. I don't know. Perhaps 8, 7, 8. Well, that's what Anna told me. Well, Anna is in 8th semester, but well, if it's not the case, that's great. When you get to those type of semesters, 8, 9, people began to only think in work and money and practice and start out a career and start out the profession and have a name and understanding. And that's all great. That is great. And it's going to come, I'm sure, for every one of you. But let's not forget about this. Okay? So once again, this is to try to be able to take you from that day-to-day specific purpose of start out being a lawyer as soon as possible. Not today. Okay? Let's just have a relaxed and okay. So the law, the American law is usually named also as common law, which is confusing. And then to confuse it a little bit more, it's always called, it's also called sometimes like case law. What is that? So common law, it's a legal system that started out in the United Kingdom many years ago, right? And in a very hyper simplistic way to say is that basically the king and all of the king's, let's say, cabinet provided legal decisions, justice, right, to whoever whoever approached the king and cabinet seeking for that justice. And those decisions began to accumulate throughout the years, right? Because there was no codification on that, especially, the United Kingdom, right, at that time. And it began to be the common law, the law to which parties in a distress, in a controversy, in a dispute, will try to look for a third party to decide to solve that controversy. And it began to be released right from the United Kingdom. Of course, the United States was not an exception. This is absolutely, I'm sure you know this, completely opposed to civil law, which is what we practice in Mexico, other countries in the civil law system. Now, there's a lot of connections now in common law and civil law currently. We can have another session on that. But in the end, case law, can you go back? Case law is an authority set by previous judicial decisions on a particular issue or topic. Legal system, right? It's a legal system, and case law to the actual compilation of cases. Now I'm talking about the US, by the way. Forget about that. Case law, it's basically the compilation of cases that are solved from lawyers. It's basically to be very acute and quick to be able to connect the case that they are pursuing or defending, prosecuting, not whatever the position they are in that case, to previous cases, to try to connect the story that this lawyer, Fabiana Boites, is now defending to some other cases in the past, which facts are basically the same as mine. And because those facts are going to be able to help me out, to push my case, to push my defense, whatever the position I'm in. We'll get to that later. But that is basically case law. Now, you may imagine that these are thousands of cases, perhaps in the millions. In the past, when there was no computers and systems, and it was basically a homework, a task of going and extract cases from books, right? These lawyers were more talented before, because they had that possibility. Otherwise, they couldn't do it. Today, there are very robust systems, computer systems, such as LexisNexis, for instance, or West, which basically, in a single computer, throughout a system, you can access whatever case you are seeking for, and whatever topic, contracts, torts, whatever, criminal prosecution, and it might expel, produce an answer for you in minutes. I'm not saying this is now an easy task, but it's certainly, in terms of the procedure of it, easier. LexisNexis and West. I know these are very expensive machinery, as you can imagine, but I've learned that some universities have them, just in terms of consultation for academic purposes. This is just like a tip that might be interested for faculty. I'm not getting any commission for sending West or LexisNexis by hand. So those are the systems in which, at least those two that I know, that basically compile all the case law that there is. Now, perhaps my case is in California, and it deals with a car collision in which somebody died. And so I'm going to be very specific on trying to make that input in those systems to result in similar cases. That is case law. Is it clear? So I think for the purpose of this slide, it's easier, not easier, it's better to refer in terms of a legal system. I would refer it as common law. What type of legal system the US has? Common law. But when we refer to case law, you're now referring to something more specific, which is a compilation of cases, right? When you refer case law, you don't have to necessarily refer to all cases at federal and state level. You might say, I'm referring to case law in Massachusetts, for instance. Right here. Good. Good. Now, another interesting thing. In the common narrative, and I mean pictures, movies, series, TV shows, Netflix, Suits, and whatnot. And I can see the girls saying, Suits. I know. Like those guys. Typical narrative, it's that case law and courts and whatever is decided at court, it's on the top of every source of law in the United States. That's usually what they pitch us, right? They don't talk about laws or codes or statutes, it's rare. It's more attractive in the common narrative to refer to precedents and decisions and right. Well, it's important to know that, go to the next one, please. It's important to know that in terms of the sources of law in the United States, it basically resembles the same logic and hierarchy that we have in Mexico. The written law, and for that means enacted law, which in other words, it's law produced by Congress, whether federal or state, it's at the top. At the top, it's the Constitution, of course, as our own system. And this is where things begin to connect. Common law system, civil system. In our civil system, Constitution is at the top, isn't it? In terms of sources of law. Yours is the same. But we're not, don't that disconnect, is it? It's the same. And then you have statutes, which by the way, statutes is not like piece of art, like no. Statute is a natural law. If there is an environmental, for instance, an environmental regulation that it's there to determine that by 2050, all cars must be electric. That's statute or law or act. Three words are synonyms to determine the same, which is law produced by Congress, whether it's a federal law produced by federal Congress or it's a state law produced by state Congress. Are we good? So that's why it's referred there as enacted. You see that within that same word, we have the word act. Enacted. ACT. Act, it's a law. Statute, it's a law. Law, it's a law. Three words to determine the same for the same name. In terms of the hierarchy, as I was saying before, Constitution as the federal or in constitutions, because every state has its own constitution in the US, as we do as well in Mexico. And then we have the statutes. And then we have the international treaties, which are entered by the executive power, the executive branch, and ratified by the Senate, same as in Mexico as well. Oh, by the way, this is a parenthesis. We're going to do a little bit of comparative law. Saying now. And then you have court rules, meaning the rules of how the court has to process certain litigation, etc., dispute. And then you have all those rules that are there to govern the administrative agencies. We'll get to that. Administrative agencies are basically all those big offices that depend or report to the executive branch. We'll get to that in a minute. We have a couple slides in that. And then afterwards, on the next step below, then we have case law, right? Then we have the judicial common law case law, basically all the, as I was saying before, all cases resolved in the past. And then we have case law interpreting enacted law, which are basically cases that are resolved on a controversy of, I don't know, challenging a new law, right? And then we have those administrative agencies that have some sort of quasi-judicial authority. Again, we'll get to that later. But those are also a source of law. We have the same right here. It's pretty similar. And then we have secondary authorities, as we also know them in Mexican law as well, which are basically commentaries on law, books, journals. Another big important parenthesis here. If you have time, and I'm sure you don't have a lot of time, but do it. Go and check law journals of American universities. They're usually for free, and you'll learn a lot from them. Every major university, they're not even major universities, middle universities, they have their own law review. Those are the journals, right? They basically produced by teachers from those universities, or I don't know, alumni, meaning students that were formerly a student, former students of those universities, etc. And they produce their own, every quarter, let's say, their own journal with very interesting articles. You can learn, I've learned a lot from them, and I'm sure you can do as well. The best, Harvard Law Review, it's for free. Yale Law Review, Stanford Law Review, Berkeley Law Review. It's all for free. You can get marvelous articles. It's great for arm strengthening in terms of practicing English, of course, and it's highly technical, right? But to the extent you can manage that type of technicalities and language, you're gonna be doing great. There is one, by the way, which is called the Mexican Law Review, also for free. I believe that's produced by UNAM, but that's English written articles on Mexican law. They're great. Mexican Law Review, please. All right. The structures of the courts in the US. It's always a pyramid, right? We have the trial courts, intermediate appellate courts, and the Supreme Courts. But we have the same. That's in Mexico. Can we go to the next one, please? This is to show that the court system in the US, as we do as well, it's a dual system. The same pyramid goes for federal courts, and the same structure goes for state courts, right? 90% of the controversies that arise and get to trial in the United States, because there's a lot of disputes every day, but not all of them go to trial, of course. But those who actually get to trial, get to court, 90% of those are here at state courts. Contract controversies, divorces, problems with a will, all of that, it's here, right? How can we determine whether a dispute should go to an state court and travel all the way to the state Supreme Court or even the federal one, or should go to a federal court in this system? It's not really that easy to determine that. But if a controversy is regulated by a federal law, that controversy should be observed and ventilated before federal court. Sometimes, once again, it's not that easy. And sometimes very minor cases become federal cases, which is, again, a very exceptional type of case. I'm sure you have heard in the movies, I'm gonna do this. I'm gonna make a federal case out of this. Wow. Why is that? Okay, well, it's very expensive, for instance, right? That's for starters. It's very expensive. It's very complex. And not all type of law firms can deal with matters in federal court. Because once again, almost everything gets run here, right? I'll give you a quick example. There's many cases, but there's one recent case in which somebody very young, such as you are, went to, I don't remember the name of the store, let's say Clase. It's another one. It's called Bershka, or can you help me out? Yeah. I'm sorry, I'm so out of it that fashion is very far away from me. Anyway, Clase. And this person was a very young lady. She asked for work. She was a Muslim. And she needed to wear some sort of scarf, and he has that piece of clothing has a name. I'm sorry. It's no? That's the one. Thank you. And she was wearing it, and she stayed there for a couple of weeks, perhaps like for 1 month on that new job, summer job, and she was kicked out. And the narrative for her dismissal was that she was not coined or somehow adopted to the fashion expectancy of Sarah's store, right? It requires some other modeling, and when she began to wear this, Sarah thought, well, this lady might scare customers away. And she said, let's sue. I'm going to sue Sarah for this. And this, you might think, well, this is a summer job. This lady was going to make 5,000 pesos, right, for the whole summer. This is a very small matter. Not for the US. In the US, they're pretty litigious, right? They like to litigate a lot. And there's a lot of law firms trying to capture litigation for free for the clients, to make it contingent, and then to pass the bill to the party to be blamed. Going back to the case, that person was dismissed. A law firm and an association of human rights began to help her. And they told her, this is a felony case. What? Why? Well, because there is a law, there's a statute, not a decision, not a judicial decision. There is a statute dated 1964, which is called Civil Rights Act. Civil Rights Act. Pushed by, in Congress, by Mr. Martin Luther King. Right? This was the, let's say, culmination of all those riotings that began in the 60s. It ended up in a law which protected minorities. And in some parts, Section 7 of that law indicates that no one can be dismissed of their job as a result of discrimination for their religion or sex or gender, etc. Federal case. Federal case. And those types of small cases, even though they could be meaningless, they enter into this fighting, right? It's very interesting. You cannot understand how interesting it is to learn the type of cases that actually reach the Supreme Court of the United States, the Supreme Court of the United States, out of basically no. Absolutely. Well, if it's a human rights protection case, it usually does to. It usually goes to federal court.
Or especially in the United States,
Definitely, the Civil Rights Act. It's a very large and robust piece of legislation that basically protects discrimination in terms of gender, in terms of basically minorities, right? And it's very much referred every time there is a violation against it, and it becomes immediately a federal case. Yes, right. Just a matter of numbers. District courts. This is where all starts. This is the actual trial court. This is what we see in the movies. This is where parties actually stand, and they go, and the lawyers are here. Plaintiff, defendant. Plaintiff is the party that starts the claim. The defendant is the other party. And then you might have the jury. If it's a criminal case, perhaps if it's a civil case also. And then you have the judge, and sometimes there's both. All of that happens here and here. Okay. Thank you so much. Thank you. Hopefully it doesn't very hot. Thank you. All of that is here. In both cases, I'm sorry, state courts, there's 50. It's at least one state court for every state, right? There's at least, not at least, I'm sorry, there's 94 district courts, trial courts throughout the United States. That means that there's some states that have to be covered with one federal district court, right? Then we have the appellate courts, 39 in 50 states. And then you have the Supreme Courts, there's one for every state, right? This is usually, again, the same hierarchy. There are very small states, such as Maine, for instance, Maine state. They skip this one, right? They just have this one and this one, right? Now, this is the common name that they use, state trial courts, appellate courts, Supreme Courts. But in real life, they change their names a lot, right? I believe that New York Supreme Court, which is state Supreme Court, it's something like New York Supreme District Court. I mean, they do their own reason, right? But in terms of the scheme, this is the one, right? And then you have 13 circuit courts, and then you have the almighty Supreme Court of the United States, the federal one. Any questions so far? Are we doing good?
I have a question.
Sure.
What's the meaning of the word hierarchical? I don't know.
Hierarchical. Hierarchical derives from hierarchy. Hierarchy. Right? Who goes first and who goes after? American hierarchical court system. Mm-hmm. Anyone else? Okay, please. Let me jump into the following, please. Can we go to the next one? Thank you. All right, so that was only for, the prior slides was just to start out. What I want to see with you today are basically these three concepts, which are basically the backbones of constitutional law in the United States. Checks and balances. Have you heard about that? No? Okay, great. We're gonna have some fun. Stare decisis. Sounds like a disease, isn't it? Stare decisis. I'm sorry? No? Yes? No? And judicial review. Okay. I'm gonna try to go a little bit faster because I would like to cover everything. Okay, so checks and balances, please. Let's start. Thank you. We all know this, right? Three branches of government. No question about that, right? Legislative, we have the Congress, we have the Senate. Congress, by the way, yeah, it's House of Representatives. Congress means both chambers. House of Representatives with congressmen or congresswomen, and we have the Senate, and then we have the Senate, senators, right? 100 senators, many congressmen, congresswomen, around 500, I'm not wrong. The executive branch, headed by the president, of course, and vice president, and the cabinet. I believe 15 ministries, which is the secretary, right? 15. And then we have the judicial branch, which is Supreme Court and other federal courts and other state courts. It's phrased here like this, because as we're going to see in a minute, the Constitution of the United States, which is a very short book, only refers to the judiciary or judicial branch. By the way, you can refer to judicial or judiciary branch as being comprised by the Supreme Court and every other courts that Congress might decide. We'll get to that. Typically, ordinarily, we understand that legislative makes laws, executive enforce those laws, and judicial interpret law. That's 101, isn't it? That's simple stuff. Things began to complicate when these branches began to mingle and step over one to the other. And this is when things are become very interesting in terms of how to follow how they intertwine between them. And that's exactly checks and balances. Checks and balances, please, the next. Oh, let's skip, please. We'll get to that. Yes, next. Okay, this is just to refer, sorry, how the Constitution referred to those branches of government. Article 1 determines, basically describes the legislative branch. Very interesting stuff. I've always thought that the president, in terms of the Constitution, was the most important branch of government, the executive branch, isn't it? The president is the almighty, whatever. Mr. Trump. Okay. So, well, no. By the time the Constitution was enacted, the most important branch of government was Congress, was the legislative branch. Why? Because it was the legislative branch that was creating a nation that was newborn. And they require regulation and rules, not as much as somebody enforcing those regulations that didn't exist in the first place, right? Remember, there were 13 colonies in the United States that began to put in their ideas and efforts together to create the United States. That's the story. Right? So they decided that the first branch of government in terms of importance was the legislative branch. And then they jump into the executive branch. And then in the end, and with very little care, the judicial or judiciary branch, Article 3, right? There are only 7 articles to the United States Constitution, only 7. With a lot of subsections, there's only 7. And 27 amendments, meaning reforms or changes in more than 200 years. Interesting phenomenon. All right, next, please. Checks and balances. Linked to the separation of power principles, provide each branch of government with individual powers to check the other branches and prevent powerful. That's basically it. Check is to be able to review and to assess the performance of the other branch of government. Provide the branches with some power to appoint or remove members from the other branches. This concept, though it seems very important, it's not in the Constitution. It's not referred to. It comes from doctrine and from legal thinkers such as Montesquieu. You might remember that French guy, right? Separation of power principle. Locke, Montesquieu, all those guys, English, French, French Revolution, right? All that comes from, all this comes from there, right? Checks and balances. Let's try to give us some examples. Can you please? Can you see this? It's important. Can we lower the light perhaps a little bit? Better, isn't it? Don't fall asleep though. I'll be watching. Okay. Let's start with, for instance, this, by the way, these are the 3 branches. You can see them, right? Executive, legislative, judicial. Let's start with executive to judicial, the connection between those 2. It reads here, the president appoints judges to fill vacancies. The president can grant reprieves and pardons. So, what does that mean? Well, that means that the executive branch will always have to intervene in the decision of selecting who is going to be occupying the seats of the judicial branch. This is not something that the judicial branch can do by themselves, right? Even though it's a separate branch. Don't we have that in Mexico as well? Checks and balances. No, sorry, checks and balances. The balance between branches. When in 2019, 2016, let me get the year right. I believe it's 2016. One of the members of the Supreme Court, Justice Anthony Scalia, and justice is not justicia, it's ministro, by the way. Justice Anthony Scalia passed away. Justices are selected for life. Imagine that, for life, not like Mr. Sandiva. Right? We can talk about that later either. He passed away. There was an open seat. There are 9 seats. Perhaps you saw real quick the picture I was showing before. There are 9 justices. Right? At that time, the government was in charge of government. Let me rephrase that. The president, the administration was in charge of President Obama. Justice Scalia passed on February of that year. Obama was about to end his term in November. There was already an election going on, I mean, in terms of candidates, etc. And they said, well, Obama, of course, as every other president, always liked to put their own judge or justice, which is going to be somehow aligned with, I mean, in terms of political philosophy, policy, concept, right? If Obama administration is basically a democratic government, right, from the Democratic Party, they would like to have somebody that would feel that seat, having those same ideas of the Democratic Party, right? Meaning not conservative, which is more inclined to Republican Party. You see what I'm saying? Somebody that is going to shape policy in terms of being more progressive, perhaps more protection in human rights, more protection in terms of environmental matters, less protection to people that want to have the right to bear arms, right? Or to go against climate change. And this is the typical narrative. It's very clear to understand Republican side, Democratic side. These are the 2 balances, or the 2 items are always balancing, right? And of course, there's always somebody in the middle, right? So the Democratic Party at that time, being Obama president, said, I would like to fill out that vacancy because that's on my constitutional rights to do so based on checks and balances. But the problem was that even though he is entitled to propose, right, to fill that seat, legislative also, as part of that checks and balances, have to participate in that decision. So it's a 3-party decision, really, right? 3-branch decision, because as you can see here, legislative can refuse judicial appointments. It's almost impossible, right? So we have President Obama being from the Democratic Party, and at that time, the legislative was filled out by Republicans. And when Mr. Obama decided to propose his own justice, Garland was his last name, legislative said, no, I don't like that now. Why not? I'm not obligated to tell you why I don't like that guy. I can always say just no. It's childish, but this is constitutional law. It's always very political, right? But this is how things really happen. And then he proposed somebody else. And you know what this guy said? No. And yes.
So there are probably like people inside
I'm really sorry. Can you repeat? I couldn't hear you.
So what is like people inside the legislative audience are having the same ideas of Democratic people.
Uh-huh.
Is there not a conflict of interest?
You mean if there is an alignment between the executive branch and the legislative branch?
Yes.
No. That's one. And that's, I mean, if that's the case, should we repeat the question for people at home? So I don't know if they, I'm gonna repeat for our friends there. The question was, if there is an alignment between, if there is the Democratic Party in charge of the executive branch at some point, and at the same point or during the same term, the legislative branch is also controlled by the Democratic Party. The question is whether it's a conflict of interest. No. No, because that's the result of democracy, right? The legislative branch was selected as such, being all Democrats or a majority of Democrats, because people voted for that. That's exactly what is happening now, right? President Biden, as a result of this election, it's controlling also, not him, the party also shaped Congress, right? So he's in a great place right now, because whatever he pitches can be not easily, because there's not sufficient majority, Democratic majority at Senate level. Decisions at Senate, most of them require 60 votes, right? He's at 50 right now in terms of the numbers of Democrats in the Senate or Democratic senators. So he requires always to have 10 guys jumping ship, right, to his side. But the answer is it's no. At that time, there was this disalignment. So whatever Mr. Obama was trying to process, he was rejected in terms of justice selection. Time began to elapse, right? It was February, March, April, June. There was an election in November. And the Republicans, they were trying some political move to say, if we win the next election, we're going to put our own justice, right? We're going to put our own Republican justice in the court. And these guys are very important. Really, they shape the political and public policy in the United States. I mean, perhaps because we're lawyers, right? But for me, they're way more important than the president. Just in terms of how much they spend time in the bench, right? Just a lifetime tenure. Well, the Republican Party succeeded on that. President Trump won. First thing he did, fill out that vacancy. And afterwards, somebody else stepped out, from the court. And Trump put another guy, another person, another justice.
Sorry.
Yes.
What was he do during the election?
He couldn't do it.
So
Just after the election.
Trump was
Exactly. And I mean, and that's not because it was an election time. It was not because of the election. It was because they couldn't find the right negotiation, political wise, in Congress for the candidate of the president to be the next justice. They couldn't do it. So even though a president, once again, it's an almighty, powerful seat, sometimes he cannot even control the opposite party within Congress. And that shapes how things move. There was a lot of problem back there because it's a nine-justice court. For months, it became an 8th court justice. And at that time, it was pretty balanced in terms of justices appointed in the past by Democratic governments and justices appointed in the past by Republican governments. So every other major decision usually got a tie. And that's a problem. Because if there's a tie, well, the lower court decision stands, right? So there was a vacuum, let's say, for a while. When Trump wins, first thing he does, fills that vacancy. How did he do it? How? Well, because he had the legislative branch on his side as well, such as Biden is sitting right now. Isn't that what is happening right now in Mexico as well? Well, right? It's all the same. Okay. To wrap up that story, currently, after that reshaping of the court, which was pretty much balanced in the past by having 4 Republican appointed justices, 4 Democratic appointed justices, again, in the past, in previous administrations, and 1 justice being always a swing vote justice, sometimes with a Republican, sometimes, and ironically, is the Chief Justice, because by the way, there's 1 Chief Justice and 8 associate justices. That's the right.
What is chief?
Chief? Okay.
Like,
Exactly. But this is for the courts, the Supreme Court. I mean, yeah. So Supreme Court has 1 Chief Justice, 8 associate justices, right? And you might, I mean, once again, go into the Supreme Court website anytime you like. There's actually a blog, which is called SCOTUS blog, Supreme Court United States. It's marvelous. It's eye-opening phenomenon. I was trying to wrap up. I said that current configuration after the Trump administration of the court is 6-3. 6 Republicans, 6 appointed justices from Republican administrations, only 3 from the Democratic administrations. It's unbalanced.
Does it depend as well on the, like here in Mexico, on the votes, number of votes? Or how can they get 6 seats from 1 country?
Well, only Mr. Trump appointed there are 3. One thing has to happen. You know, it's not a voting thing. It's a matter of a president appointing somebody and being ratified by Congress, as we saw. To the extent that seat becomes vacant. That's it. Either 1 justice, because they get too old sometimes in the bench. They either step down or they can die. I mean, sorry, but yeah, they pass away. So there's a fee to be done. Trump, I hate that guy. He was a very lucky guy in that term. And one of his, let's say, memoirs, it's the reshaping of the Supreme Court. But he was able to put only in 4 years 3 justices.
Because they were
Justice Ginsburg, which is, I don't know if you know her. She passed away very recently. She's like a rock star. She has its own movie. She made a lot of this academical sessions. You know, she has a lot of books, etc. If you don't know her, Ruth Ginsburg. She passed away immediately. She passed away during the Trump administration, and the vacancy was filled out by a Republican justice. Another name, Amy Koretz, if I'm not wrong. But the current configuration is 6-3. So back to checks and balances. Biden might have a very, let's say, comfortable position in terms of being Democratic executive branch, Democratic legislative branch, but not a Democratic Party, not a Democratic appointed court at this point. Now, sometimes I believe the devil runs around President Biden's, or perhaps one of their, I don't know, officers in the White House said, we have an idea. Why don't we, since we are able now to appoint judges and justices to the Supreme Court as well, which have to be ratified by a legislative branch, which by the way, we control right now. Why don't we reconfigure the court, and instead of having 9, why don't we make it 12? And instead of having 6-3, we'll have 6-6. It's better than 6-3, isn't it? Or instead of 12-13. Why not? It's a very risky political move, which might not end up well. I know, I mean, there was an article that was published in the New York Times some weeks ago saying that there's some commission analyzing that possibility. But the only person that tried that before was President Roosevelt back in the 30s when he was trying to put together the country after the Great Depression. He was producing all of these laws and executive orders, which were being blocked by the courts, especially the Supreme Court. And Mr. Roosevelt said, we need to do something about this. Otherwise, my plans are not going to be mature at the end. And he tried to, what they call pack the court, to pack the court, to put extra members there. It didn't work out. I don't think Biden's going to do that, but it's always, for all of us, great to follow it. I'm pretty sure, because that's what the article read, that the commission is going to produce an article about this, an analysis, an actual document. It's going to be public. It's going to be ready within this year at some point. So we need to follow on that. I'm pretty sure it's going to be great reading. Good. That's part of a checks and balances. There's a lot of connections. I don't know if, yeah, I have still a little bit of time. What else, for instance? The executive to the legislative. The president here is the commander in chief. So what? Well, he controlled basically all the defense, right? Air, sea, and land. Does the president can go to war without going through Congress? Nope. It's another checks and balances. Well, but we know that he's the he's the commander in chief, and he has those buttons that we have seen in the movies as well that he can push, and boom, right? One bomb is thrown out in China. Well, that allegedly, constitutionally speaking, cannot happen because war has to be declared by Congress before the actual commander-in-chief can enforce the decision coming from Congress. Has that happened in the past?
Last 2 wars.
No. Because, and this is where lawyers come in, it reads war. And what is a war? Well, it's supposed to be a dispute between nations. Okay, so let's call it different. Because war has to be processed through Congress. Congress might be opposed to the party that it's the president at that time. What if we call it a terrorist conflict? Oh, well, that's not in the Constitution. Well, let's start out that. And if someone is challenged in the process, well, perhaps it will be too late. You see? It's always a matter of words. Words are dangerous. Because a president, of course, his team can play with words, not call it war, and with that, elude the responsibility of Congress, right? Especially if it's not on his side, and do his own thing, right? Mr. Calderon here in Mexico called it la guerra contra el narco. Is it guerra? Well, I thought that guerra was a conflict against a nation, right? The narco is not a nation, not that I recall of. Estados Unidos and narco? No. But they call it like that. It's a war then. Why? Because it had some methodology to it, some impact, right, in terms of people to capture. It's always playing with words. Well, there was more examples. We can take the whole day on those arrows. Another interesting part, it's how branches of government act as other branches of government. That's a very interesting thing. Any questions so far? I'm going to jump a little bit on topic. Okay. So as soon as he got in office, Mr. Biden said, let's produce executive orders. And what the hell is that? 17, 25. Well, that picture was what he was signing. 17 executive orders. What is an executive order? What is it? Have you thought about that? No? Decretos presidenciales. Why does a oh my God. Yeah, you can light it up. Yeah. Okay. Why does a president has to produce executive orders? Well, because first of all, he's entitled to do so. The Constitution provides that authority. Well, is that executive order law, or should be considered as something as solid as a statute or as an act, such as the Civil Rights Act that I was referring before? Yes. It's part of those sources of law that we saw before. Great. Does that executive order has that type of authority, such as a act or statute coming from Congress? The answer is yes. So why does the executive branch becomes or uses the costume of the legislative branch to produce something that resembles a law? Well,
For emergency purposes?
okay. Any other? Good. Any other situation in which an executive order could be in order? I'm sorry? Okay, public policy.
I heard once that any reason
It's sufficient enough. Absolutely. Yeah, he doesn't have to consult with basically anyone to produce that. Once again, and I'm sorry, but it's politics. Politics. What if Congress is not on the president's side at that moment? What if it's not it's perhaps an action, immigration action, for instance, that he wants to process in Congress, but Congress it's in conflict with the president because they belong at that particular moment to the other party, the Republican Party, the president being the Democrat. This is what happened to Trump at some point. Trump began when he won the first 2 years, the Republican Party controlled executive branch, legislative branch. Then came in the middle term election, right, 2 years after his tenure, and it was reconfigured. And then the Democratic Party controlled the House of Representatives, not the Senate. So Mr. Trump was beginning to get anxious. And he said, let's produce all of these executive orders, right, to do as I please. For instance, and most of them, for political reasons also, because he was trying to capture the election that was coming in 2 years after, right, his own re-election. So he said, you know what, why don't we ban or prohibit the entrance to the United States of people coming from 7 or 8 different countries, which we know for a fact that they have a Muslim majority, right? What? Why? Well, this country like, I'm sorry, I remember, it's Chad, Nigeria. We never had any conflict with those countries, Mr. President. Why do we have to? I don't care. Executive order. Could that be, that nonsense could be processed throughout Congress at that time? Absolutely not. So he didn't have to go there, and he can produce his own executive order. Is that law? Yes. Is that challengeable in court by somebody that feels offended or violated his rights? Of course. We'll get to that later. That's called judicial review. Right? But initially, that's an executive order. And for that reason, the executive branch becomes the legislative branch. When Mr. President Biden came in, he signed all those executive orders to overturn all of those that were produced by Trump. If Trump said, we don't allow people coming from those 7 Muslim countries, which was called, by the way, the Muslim ban. Ban is prohibition, B-A-N. He said that can no longer be there. So he basically overturned that decision. How? Through a new executive order, right? And the same was for immigration, for Mexico and Latin America, Central America, etc. Environmental matters, etc. He said that's the first thing we need to do, and that's when he started. That's an executive order. Yes.
So the checks and balances interfere in the executive orders or just like are filed?
Great question. The question was whether how does checks and balances play in the executive order? Yes, absolutely. Checks and balances are basically everywhere. Somehow meddling between the three branches of government. To answer your question, I tried to say it before. It's the let me phrase it this way. You take the executive order, you read it, and then you take the Constitution and you read it. You say there's a conflict right here. Right? There's a conflict. Somebody felt violated by his rights or her rights as a result of this executive ban, Muslim ban. This should be challengeable before courts. The court, at the end of the story, has authority to challenge every other piece of legislation, either coming from the legislative branch or the executive branch. So the checks and balances there balance the authority that the president has to produce the executive order. Judiciary might come in and say this is non-constitutional and shuts it down.
So it's up to whoever is judging.
Well, yes, absolutely, absolutely. But yes, the answer is yes, but it's also based on the checks and balances perspective. It's based on what the Constitution allows for the judiciary to do in terms of questioning decisions coming from the other two branches. More or less?
Yeah, it's kind of like for those cases, we advise that we have to like control the controversy.
Yes. Yes. Acciones inconstitucionales. That's so difficult to pronounce. Very jumpy. Okay. Executive branch acting as legislative branch, producing executive orders. We kind of understood why. Can we go to the next one? Legislative branch acting as judicial branch. How is that possible? Well, in the impeachment cases, which I'm sure you read thoroughly throughout the Trump administration, was not once impeachment, but two impeachment processes. There is a special process within the Constitution in which not only for the president, but other members of cabinet or members of the judiciary as well can be impeached. And impeached, by the way, is only to say the Constitution indicates that something can be subject to process. That doesn't mean that the party is to be convicted immediately only for the fact that it's being impeached. That's why Trump walked away twice. Not because he was free to go, right? But because at the end he was not convicted. And why? Well, because the Senate becomes some sort of quasi-judicial body of government which processes as in a court an impeachment claim, right? It's very special. It's a very special type of justice process, let's say. The president doesn't go to court because he's being sued. No. If he's going to be removed for some reason, that process is going to be ventilated under special circumstances in the Senate. And who's going to run that, by the way? And he's going to be the judge, actually. Well, the Chief Justice of the United States, the Supreme Court. He's going to be sitting in the Senate, as he was, Chief Justice Roberts. He was sitting in the Senate. The only problem was that the parties that were putting together a claim, an impeachment claim, the articles of impeachment, as they call them, were obligated to convince for that impeachment a jury. And who was that jury? Who comprises that jury? Senators. But the problem is that senators are all Republicans. Politics once again. They could never vote against a Republican president, isn't it? And that's why he walked away twice. You see, he was impeached, meaning process in Senate in that very special circumstance, but he walked away. Never convicted. And by the way, what was the result if he was convicted anyway? For that reason, he's going to jail because he did X and Y? No. The only result of that was that he was no longer be acceptable to run for office. Once again, in his life. That was the penalty. Right? Legislative branch acting as judicial branch. Yes? Do you want to stop for a minute? Should I continue? We can continue on the next slide and then we can break. Is that okay? All right. Let's skip to the next one. Those are the articles of the Constitution that refer to impeachment. We can. And then judicial branch acting as a legislative branch, right? This is a case that is called Trump versus Hawaii. I wanted to post this for you because this is how basically a very long, complex case it's summarized. And it's the ability to do so. That's something that you also have to check with my friends, los gringos. They're very, very well trained in how to process large pieces of information, analyze that information, and synthesize that information. It's amazing. That's something that we should do. When I read this and I read an amparo, oh my God, there's a lot to do, right? Because here in Mexico, lawyers think that to the extent they say more words just to say the same meaning, they're better off. They're not. Judicial branch acting as legislative branch. And then again, I included this case, which indicates the docket, which is the expediente, basically. The court in which it's going to be sitting for its ventilation, the Ninth Circuit, right? Appellate court. The date, the opinion in which, or the date in which the opinion was, the opinion is the sentencia, right? Could be opinion or decision in which it was produced. How did the court vote it at that time? 5-4, it was still a 9 justices court at that time. The author, who was the presiding justice producing that opinion? Justice Roberts. Not always, not every time for every case, the same justice produces the same opinion. Right? There could be one opinion, which is going to be, for instance, the majority opinion, which makes the case go, in this case, 5-4, the winning opinion. But there can also be a dissenting opinion by saying, we democratic justices, we do not agree with that opinion. We're going to produce our own. We know that on this case, we're going to lose because it's a thing of majority vote, right? 5-4. But that's the majority, that wins. But even in that case, I'm entitled as a group to produce a dissenting opinion. Why and in which terms we do not agree with that opinion. All of that can be found in the Supreme Court website for every single case. And this is the term of the Supreme Court in which this opinion was produced. No, accepted. Holding. Meaning this is the ground of the case. This is the actual motivation for this case. That's the holding. The president has lawfully exercised the broad discretion granted to him. This is, let me rephrase, this is the argument. But one of the parties the party that is approaching the Supreme Court has for that case to be ventilated in the court. That's the argument. The president has lawfully exercised the broad discretion granted to him under A, USC, United States Code System, to suspend the entry of aliens, this is not ET, aliens are foreigners, into the United States. Respondents, meaning the counterparty, have not demonstrated a likelihood of success on the merits of their claim that Presidential Proclamation number X violates the Establishment Clause of the Constitution. That's a clause that is in the Constitution. And then you have the judgment. In an opinion by Justice Roberts on June X, Justice Kennedy and Justice Thomas filed concurrent opinions with what is opinion. Justice Breyer filed a dissenting opinion in which Justice Kagan joined. She's a Democrat. She was appointed by Obama in the first term. She was, by the way, the dean, rectora of Harvard Law, before becoming the Justice of the United States. Justice Sotomayor, Latina, by the way, the Latina justice that we have there, filed a dissenting opinion in which Justin Ginsburg joined. That's it. Why did I include this slide? To show you that the judicial branch acted as legislative branch, because this is the production of case law, right? This case, in the hierarchy of sources of law that I showed you at the beginning, even though it's a little bit below that than constitutions, acts, statutes, etc., it's there. It has the same power, not the same. It has a very robust power to be considered as law for next cases to be resolved. It's what it's called also precedent, not president. No, precedent. Case law, it's filled out by precedents, right, that are going to be considered for future cases to be resolved, right? Judicial branch acting as legislative branch. Question? Right? 10 minutes? All right.
Estoy viendo. Sí. Oigan, vamos a suspender unos 10 minutos y ahorita volvemos. Se pueden quedar conectados o volver a entrar, pero les sugerimos que se queden aquí conectados. Esto.
Publication that was done to DACA was very short, once again, wording, very weak wording to end the book, right? Basically, without any type of explanation. And we all thought, well, the president can do whatever he likes in terms of overturning executive orders. Well, this proved wrong, and we'll see it in a minute. But then again, he committed a procedural mistake in terms of not providing the right motivation as to why to end the book. Okay? After it was the program was ended, there were challenges, right? Meaning lawsuits filed in California, the District of Columbia, which is the 9th, New York against the decision to end DACA. Very progressive states and states that we can easily watch that are benefiting out of the work of those guys, right? All of them are in Mexico, Central America, etc. Or New York, DC. Which were the challenges? Well, included states, cities, universities, DACA recipients, civil groups, civil rights groups, and even Microsoft argued that the decision to resign DACA, which is to end DACA, violated the rights of DACA recipients and the Administrative Procedure Act. So there's something more substantive here. It's the fact of that they were claiming that there was some law that was being violated as well. we have saying here? An Administrative Procedure Act. It's part of the administrative law, isn't it? The federal law, Administrative Procedure Act, that was violated was the federal law governing administrative agencies, claiming the challengers that the decision was arbitrary and capricious. In other words, childish. And infringed, which is violated, and infringed the equal protection guarantee of the Fifth Amendment's due process clause, which is found in the Constitution. So once again, we need to enter once again in the checks and balances perspective and say, okay. So even though we thought that the executive order can be weak and be overturned by the next president, now we know that a decision to overturn it as it was presented to overturn it violated a certain law that is called Administrative Procedure Act. And not only that, apparently it also violated a provision of the Constitution. So that means that the judicial branch can jump in to the discussion. Can they automatically jump into a discussion? Absolutely not. Someone, either a person or persons or entity or entities or a combination of both, have to show standing before the court by saying, I'm really damaged as a result of this. And I want the court to hear me and process my claim. It's not an automatic mechanism in which the court can jump in, even though it can be a very blatant, opening, violating decision to overturn that program. Are we clear? Are we following? Yes or no? Yes? Okay. There has to be, the parties have to have standing. So all of those challengers got together and said, there's at least two violations, law and Constitution. Next, please. Yes.
So these executive orders
Can be canceled by the next president. Yes, absolutely. This is what we said before.
Can be or
Can be, definitely. You saw the picture of Biden signing executive orders before in one of the previous slides. He was actually overturning executive orders produced by the president, by the Trump administration. Yes, they can be. However, as we are learning from this case, the way to overturn those, it's important. There has to be some procedure to be followed. Otherwise, some laws that are there in the legal system can be violated, and that should not happen. And to complement my comment, the form in which they are overturned, it's important. And if that form, or perhaps substance or form, are violated, the decision to overturn, it's challengeable in court, right? It's challengeable in court. That's important to understand, meaning that the courts always have the right to review anything coming from either the executive branch or the legislative branch.
but it has to be by order of the president. It can be like the order like the legislation. Just like decide to check.
Can you repeat the question? Let me try to understand.
It has to be by order of the president that the legislation check the executive order in question, or they can just.
The party, I'm sorry, the branch that can challenge, it's not the legislative branch, it's the judicial branch. The executive order, once again, executive order was produced in Obama's administration. Trump comes in, overturns that decision, that executive order, and people feeling violated as a result of this decision to end it, they go to court. And they challenge that decision to overturn that decision, and court jumps in. Why is this checks and balances? Why is this part of a checks and balances? Because you have the executive branch producing a decision, in this case, to end an executive order, that is challengeable in another branch of government, which is the judicial branch.
But it has to be someone complete.
Absolutely. Cities, states, even microstates. That's what I was trying to say before. There's no automatic mechanism in which the judicial branch said, something's wrong there. Let me intervene. They don't work that way. They're not the police. The judicial branch is a, bear with me in this term, it's a comfortable branch to which a party that feels damaged, injured, violated, infringed somehow as a result of a certain decision, whether it's contractual decision, whether it's a government decision, the parties need to come and approach the bench. We have heard in the movies. Approach the bench. You bring things to me. I would not step in unless you call on my door and began, as a result of calling the door, meaning filing a lawsuit, then the mechanism starts. Otherwise, that is understood that the case might not be ripe. As in a fruit, it's not madura. The case must be ripe, must be ready, and must be really a challengeable claim for a court to step in. Right? But if the claim is there, if the arguments are there, if there's precedent, as we saw before, in case law that can push for the court to study the case, then the case is going to be accepted for processing. The result might be, we don't know. But with that, it's sufficient enough for the court to step in. Do you remember the other case that it was called Trump versus Hawaii? I said, well, why Hawaii? What does Hawaii have to do with this, right? Because it was a case against the Muslim ban, right? Well, somebody felt violated. It was a Muslim family that was expecting some relatives coming from Chad, which is a country there in Africa, right? We're going to visit Hawaii. Somebody went to a Hawaii court and said, please help us out. And then Hawaii state stepped in, right? And then it was Trump against Hawaii. But it was only after that happened, not before. That once again, the judicial branch is only after the mechanism to process a case, it's when they step, right? There's been numbers of cases in which a branch might even ask, for instance, for an opinion from the judicial court saying, what do you think about, stupid question, but there was one many years ago about this. Do you think that the election right now as it is, I think it was in the 70s, it's running its right course, but don't you think that democracy is not being fulfilled? They were asking more like a political question. It was not really a case. The judicial branch says, we're not here for that. If you want an opinion, you need to go to a law firm. We're not here to provide political opinions. We're only here to resolve controversies. This is not our skin. Yes? Good? Okay. So there were three cases, right? There were three intents from different parties against the DACA decision, against the executive order to overturn the DACA program. And the lower courts, meaning not the Supreme Court, the district court and appeal courts ruled in favor of the challenges and ordered the government to keep DACA in place. In other words, saying, Mr. Trump, you cannot overturn this program even though it was an executive order. Imagine saying no to a president, such as that guy. Let me go back a little bit to Trump versus Hawaii. When that happened in Trump versus Hawaii, you know what he did? And that's a good strategy. He produced that executive order, was completely unconstitutional. A judge in Hawaii said, this is not going to fly. Okay, he went back to the lawyers. Can you please produce a new one, please? A new executive order? Whatever that guy, for whatever reason, he blocked the first executive order, he erased it, and produced executive order number 2. And he went out and he was challenged. And another judge, a federal judge, said, this is unconstitutional. He went back. Trump. Produce number 3. This is the type of persistence and I don't know how to call it. It's enraging, right? Just to try to do things as his way. And then after the 3rd executive order, Trump versus Hawaii, the case ended up in Supreme Court. And you know what happened? He won. And the ban, with some provisions being a little bit different, it's in place. We have a term. Even though Trump is out, the executive order was maintained until Biden came in. And this is
What do you think have to change in order to
it's I mean it's a lot of legal technicalities, right? Constitutional matters to try to accommodate the right wording and the right constitutional concept for that to be adjusted. But he tried 3 times. And that's another way to show you that even though it was very clear for lower courts, meaning district court, appellate court, by saying that's unconstitutional, when it reached to the Supreme Court, they said, no, it is constitutional. By a majority that we saw 5-4. And that decision overturns the lower decisions. This one, it's the one that becomes precedent. This is the one that becomes case law. It's a lot of stuff, isn't it? Saturday morning. I know, I'm sorry. Okay. So that was the order. To keep the executive order in place. So the Trump administration said, no, I want to keep fighting. I don't want that program to be in. Why? Because then my redneck friends, if I continue fighting this one, they're going to vote for me in the next election, my re-election. So I'm going to continue fighting because even though these 2 said keep it in place, I'm going to file an appeal before the Supreme Court. And that was in November 2018, when the Trump administration asked the justices to consolidate the 3 different cases. Why did he want it for that case to go to the Supreme Court? Again, politics. Because there was a 5-4, and the result could be at the end that since he was a very strong president in terms of politics, he just might get a shot, right? As he did in Trump and Hawaii. Unfortunately, sometimes it's not a matter of justice, it's just a matter of seeing strong, right? In terms of how the executive, the branch of government intertwine. At the end of June 9, 2019, the Supreme Court announced that it would review the 3 cases, and they granted certiorari, sorry. And that's that word. The Supreme Court is not obligated to hear all cases that are brought before them. They can decide which they're going to take and which they're not going to take. That knocking on the door that I was referring to before, for them, it doesn't work. They decide upon certain criteria, but they don't have to show that criteria. They don't have to explain to anyone as to why some cases is accepted or not accepted. Sometimes, usually, when there is, you remember there were 11 circuits in the federal system, right? The appeal courts, sometimes one circuit might say black, and another circuit might say white in cases that resemble, so it's different criteria. And then a new case appears in, and the Supreme Court says, you know what, let me take that one because by deciding on this new case that just arose, I'm gonna disentangle this controversy between courts of lower courts, right? And I can set out a new and more clear policy on a certain matter. That's usually a criteria to accept cases. But they only accept around 10 cases, 10% of the cases are presented. 10%. 10%.
And before the US, it needs to say the officials without having to come to the board.
They usually work the office. They usually not work the officio at all. No, that's part of that comfortable position in which I was referring. No, no, they're pretty much as the other branches of government as well, but they're pretty much limited by what the Constitution says on how the judicial branch might act, and it doesn't say much. Okay. Some questions for you. Let's try to. What do you think was DACA created by the executive branch and not by the legislative branch back in 2012? Elaborate, please. What else do you think, once again, could lead a president to say, I'll do it through executive order, not through a more comprehensive package of immigration through a law? What do you think was happening there at the time?
Well, first of all, it was, I think, like promise of this campaign. And the second, as I said before, the Triggers program was like the negotiation with the Congress were a total failure. So he introduced that as an executive order to these promises.
Exactly.
This campaign.
You're talking about Trump, isn't it? The Trump or the Obama administration? Yes.
Like that.
Yes, you're right. Yes, and only to complement that, it's basically because Obama at that time was facing an opposing Congress. Right. President Fox and President Calderon. President Fox started out in 2000, so more than 20 years ago. He appeared before Congress in the United States. You can look it up in YouTube, asking for a comprehensive protection of immigration, for an actual package of laws to regulate immigration in the US. He never got it. Even though he appeared there, he was not very good at speaking in English. He spoke in English though. And then Mr. Calderon did the same. The immigration card has always been a token to negotiate between the US and Mexico. The presidents of Mexico always trying to protect as much as possible whenever there is a Democrat sitting in the executive branch in the US, because they usually care for immigration, not the Republicans. So they have been trying, but they didn't succeed. So as part of a reaction coming from the Obama administration that at the time was facing an opposing Congress, he produced an executive order called DACA. That was the case. Because of the opposing Congress. Yes. Question for you: was the executive branch at the time of the Obama administration entitled to do so? Yes. Yes, they can. Yes, they can. Because as a campaign slogan is, the role of the Administrative Procedure Act in this case. I'm going to answer this one for you. We saw before that this act, this law, regulates, the one we have in Mexico, regulates every other action coming from the authority, los actos de autoridad, right? They're regulated somehow. They have to be motivados. All that stuff, it's the same there, right? There has to be some sort of motivation as to why even the president acts in a certain way. And he failed to do that. Perhaps he was, and his team, a little bit more caring to the extent of producing the right motivation to end that program, he would succeed. But they did not. Is the executive branch entitled to modify or end this program? We said yes. Because another president just might come in and overturn it. But now we know that with the right motivation, right? Not in a childish, careless way, because otherwise that could be subject to be challenged in court, right? By someone that can feel damaged as a result of that overturning of the program. Is the judiciary branch entitled to review the power? Entitled to review the power to review the decision to enact that something's wrong here. In any way, is the judiciary branch entitled to jump in? Yes. We already explained that.
That's the judicial review, right?
Exactly. That's a judicial review, which is very interesting. We can, if we have some time. I mean, I had it in my agenda. We'll see if we can get there. Please. Basically, these are the answers of that. Can you continue, please? Next. Okay. Next. There. Thank you. In June 2020, the Supreme Court of the United States, SCOTUS, ruled that the administration acted improperly in terminating the program. And it sent the case back, which is remanded, send it back, for the Department of Homeland Security to take another look. Basically, there's something's wrong with the way you terminated this. Try again. Right? But in the meanwhile, the program stays. The ruling meant that the DACA program remained in place. The famous Trump tweets. Do you get the impression that the Supreme Court doesn't like me? These horrible and politically charged decisions coming out of the Supreme Court are shotgun blasts into the face of people that are proud to call themselves Republicans or conservatives. We need more justices, or we will lose our Second Amendment and everything else. Vote Trump 2020. Oh. And that was the end of it. That was the end. Questions? Yes.
Were there like majority of judges aligned across?
Not on that one. It was a 5-4 decision as well. It was a even though out of those 9, 5 were appointed at some point by Republicans and 4 did not. Justice Roberts, again, is the swing vote. It's a more rational guy that says, well, sometimes I stand here, sometimes here. Another important thing, even though judges are appointed by a Democratic president, for instance, Obama, they're not obligated to produce their decisions or rationale based on Democratic views or Democratic Party views. They're completely free, right, of deciding on their best choice and legal rationale. There is some expectancy in terms of what would be the results coming from, for instance, Justice Sotomayor. She's Latina, and we can, as a result of that, process that she will always protect cases where minorities are involved because she's part of a minority. And because she was appointed by Obama, and because she's a woman, right? And you can expect that the 3 justices that were appointed by Trump during his administration might usually think the same way the Republican Party acts and says. But it's not an obligation. Here comes the irony, just to wrap up this point. There has been, hopefully I'm not wrong, a couple of African-American justices throughout the history of the court. The first one was one very close ally to Martin Luther King, Dr. Martin Luther King. There's a new movie about him that is called Who will, I think it's Marshall. It's a complicated name. Something like for good, something like that. Marshall, you can check it out, please. He already passed. He was the first one. And the other was the other African American appointed to the bench. It's Justice Thomas. He's still in place. He's in the bench. He was appointed by a Republican, even though he's an African, he was appointed by a Republican president. Right? One would expect, he being black and United States being so racist and with all that, that he would usually produce opinions based on the protection of minorities, progressive. Well, not at all. Not at all. So again, it could be just a wishful thinking that a justice might opine in a certain way because of his or her background, but it's not an obligation. And this is what Justice Roberts has been showing during very important cases. That case on the Medicaid case, the affordable the name has Affordable Act, which is a law to provide Social Security protection to every citizen. It's a universal one. That case ended up being the Supreme Court. And if, of course, was pushed by what we call Obamacare, it ended up there. It was pretty much an effort coming from the Democrats. And at the end, the case prevailed in the Supreme Court as a result of a swing vote of Justice Roberts, even though he was a Republican. There we go. All right. Please. Thurgood Marshall. Yeah, I'm always confused with the Thurgood. There's a very good movie on him, and there's a very good documentary. He was a very important man who did a lot for civil rights movement back in the day. Thurgood Marshall. Thank you. Hi. Okay, we have some minutes just to go through this. What is this? Stare decisis. It's a legal doctrine. You're saying yes, you know, not. Oh, great. The doctrine of stare decisis, et quieta non movere, which translates as to stand by things decided and not to disturb the settled law. Whatever precedent, this is in terms of precedent, right? In how cases are resolved in the past and how cases should be resolved in the future based on those past cases, which are called precedents, right? It commands judges to apply the law as it has been set out in one prior case, and by law means case law, when the prior decision was made by a court that is higher than and sometimes equal to the court rendering the present decision. The only part of the decision that is binding is the ratio decidendi, or the rule of the decision, as opposed to the extraneous comments of judges in that particular case. You can skip that last part because it's not important. But it's basically to let things or decisions stand as they were. Please.
Question that I wanted to make. Esto we hope inactividad o inactividad o de los derechos adquiridos, right?
Yep.
There's something like that in the US.
Yes. Yes.
For example, for the dreamers, that they got, I think they feel, I don't know how to say this in English, pero se quitaron un peso encima para entrar en este programa.
Absolutely.
So now they have to struggle again with their.
Well, the program stands. You mean the Dreamers program? It's still there. Yeah, it's still there.
But if it's possible for every president to change it,
You're absolutely right. They can face the same struggles if the next president is Republican. Yes. There's a very good piece in the New York Times, which, by the way, you should read every day, because that's a great source of information. New York Times every day. Not Cancha, no. Cancha, sports, whatever other, no. Devote your time to read about all these things. New York Times it's a great source. There's a great piece there that was published. I can send it out to you, which read something like, it was an editorial being produced by the New York Times, actually, editorial board, by saying, it read something like, Joe, stop with executive orders. And the message was, do not govern through executive orders because they might be just temporary and they're not long-term solutions. Go and, fight it in Congress. You almost control Congress, almost control Senate. Go there and produce long-term solutions. Executive orders won't do it because they can face that overturning procedure that we just. I'll send it to you. A doctrine used in all court cases and with all legal issues means that courts look to past similar issues to guide their decisions. The past decisions are known as precedent, as we know, like we said before. Precedent is a legal principle or rule that is created by a court decision. A precedent is a legal principle or rule that is created by a court decision. This decision becomes an example or authority for judges deciding similar issues later. We'll get to an example in a minute. Stare decisis obligate courts to look to precedent when making their decisions. Thank you. Example number one. Very primary examples. John borrows Tim's lawn mower while Tim is on vacation. John doesn't ask Tim for permission. John accidentally breaks Tim's lawn mower, but he doesn't tell Tim. He simply places the lawn mower back in Tim's garage. When Tim returns home and discovers the broken lawnmower, he demands that John buy him a new one. It was just a little bit broken. Right? He was a new one. The two end up in court, and the court decides that John does owe Tim the money required for John to fix his lawnmower. However, John doesn't have to buy Tim a new lawnmower. That's a decision coming from court. This decision, court, he doesn't just needs to produce the money to repair, but not to provide him a new one. That decision from court becomes precedent. Right? It's a decision coming from court and it's precedent. From now on, lower courts in the same jurisdiction are expected to follow this new rule. When a borrower borrows a borrowee's item and was using the borrowee's item without permission in the first place, the borrower must pay to have the item fixed. Voila. Present. Okay. Now, how can that be used in future cases? Let's see. Sure.
what is lawnmower?
Something to cut the grass. Machine to cut the grass. Hello. Thank you. Example number 2. Linda borrows Christy's car. Christy left the car at Linda's house the night before and left the keys in. Christy told Linda she could move it if she needed to, but she did not give Linda any permission to drive the car anyway. Linda gets up to work and finds that her own car would not start. Because she's already late, she borrows Christy's car. She was not allowed to do that, right? Then, on her way to work, Linda accidentally runs over her cordon and damages Christie's car. When Christie's sues Linda for the amount of his insurance deductible, the court will cite to the case of Tim versus John. Why do you think is that? That's why. And why is a precedent the other case for this one? Because, I'm sorry? Exactly. The facts basically are the same. The facts resemble. So if it fits, that's it. Right? The talent of lawyers is to try to determine, this is, of course, a very simple case, but it's usually not only one case. It can be hundreds of cases that I can go exactly resembling mine or going against mine. So the talent of the lawyers, whether it's plaintiff side or defendant side, it's to try to determine which are the actual right precedents for my case to succeed. Right? And they have to be. Lexis. When you read a decision coming from a court, which once again, you should check them on Supreme Court, which are the most intense decisions, it's almost sometimes impossible to read, at least on the first times, because they're so stamped by case precedents being referred to, you can barely follow the reading. There's many references to cases, to case precedent. With time, you can, get a little bit accustomed to that. But sometimes reading is difficult as a result of that. It's impregnated there. Yes.
So the precedents are like legit.
Meaning? Legitimate? Absolutely. Absolutely. They're legit? Yes, they are. They have to be followed. They have to be followed. Now, once again, the parties to a controversy are the ones that have to, once again, approach the court, which is going to be waiting there to see which party has the best case, right, based on precedents, to convince the court and perhaps jury that if I'm plaintiff, then my case should win. Right? That's my job as lawyer. The other lawyer is going to do exactly the same, but not exactly the same, exactly the opposite. Right? He's going to present some other cases as to why his position based on other precedent should win. Right? Yes. I don't want to confuse your people. Okay, good. So we have that. When the court will cite Tim versus John in this new case, right? Please. All right. The prior case, this is the requirements for binding precedents. The prior case must address the same legal questions as applied to similar facts, right? The higher the degree of factual similarity, meaning same story basically, the more weight the judge gives the prior case when deciding the present matter. Litigants compare and contrast, as I was saying, prior cases with their own in briefs submitted to the court. The judge reviews and weighs these arguments, but also may conduct its own research. The case must have been decided by the same court or a superior court within the same hierarchy to which the court considering the new case belongs. That's a lot of wording just to say. Precedent coming from, for instance, from Circuit 9 are going to be binding on Circuit 9 within the same jurisdiction. On courts pertaining to district courts that are distributed within the same circuit. Yes? There's no need to check on to be binding precedents, vinculantes. There's no need to check on others, on precedents coming from other circuits, but only those. Why those? Because in circuit 9, it's my case. It's going to be litigated in that circuit. So I'm going to check precedents that resemble my case from that, because those are going to be authoritative. Those are going to be binding, right? If I don't find it for some reason, there's no case that helps me out, I can use some other precedents coming from other circuits that can be used as persuasive, but not binding precedents. Persuasive, only to persuade the judge, because I couldn't find binding within the same jurisdiction. Please. The decisions of a higher court, such as an appellate court, Supreme Court, become binding precedent or obligatory stare decisis on lower courts. Precedent set by a court of same level. Imagine Circuit 9 decisions on Circuit 11 decisions, or lower jurisdiction, are often considered as persuasive authority, as I was saying before, rather than binding authority. This means that these decisions are used to guide the thought process of the judge without requiring a certain ruling. Decisions made by the Supreme Court of the United States hold the most stare decisis or binding authority on other cases in every jurisdiction in the nation. Why? Because this is the highest court in the land. So every decision coming from the Supreme Court, it's gonna become a precedent for other courts to follow, right? Roe v. Wade, Roe versus Wade, it's a case that comes from the 70s on abortion matters, right? Which the Supreme Court decided that under certain conditions, abortion was allowed, right? That's there since the 70s, have not been overturned. As who could overturn that? Only the Supreme Court, because it's the highest. No one can go over the highest court in the land. Right? Can a precedent be overturned? Yes, but only by either a higher court. Decisions made at appellate courts, which is in the one in the middle, whether federal state may become binding stare decisis on trial courts, which is the lower hierarchy, but must adhere to decisions of the court above. Let me put an example, and I think we should end with this one. Can you continue? There is a set of cases in the United States that are called landmark cases. Landmark cases. Cases which, by the importance of their decision, have shaped public policy throughout the years in the United States. That's why the importance of the courts, especially the Supreme Court. In 1896, there was a case that was called Clase v. Ferguson. These are the facts. Homer Plessy, an African American, challenged a Louisiana law known as Separate Car Act, a law, at state law. This law required that railroads provide separate cars and other accommodations for whites and African Americans. We all seen those pictures, right? We all seen different bathrooms, right? This was part of it. When Mr. Plessy was told to vacate, to leave the whites only car and sit in the African American car, he refused and was arrested by a detective. The train was stopped so he could be removed and a trial proceeded. Plessy's lawyers argue that the Separate Car Act violated Article 14, which is the equal protection under the law amendment of the U.S. Constitution. The judge found that Louisiana could enforce this law as it affected only railroads within its state boundaries. Plessy was convicted and fined. In short, segregation did not constitute unlawful discrimination. 1896. Terrible precedent coming from the Supreme Court, isn't it? Terrible. But it would only require for a new case with more or less the same facts to remove this awful precedent saying that for some reasons they agreed to discrimination. And this became the separate but equal doctrine. It was in an state law coming from Louisiana, which was challenged, trying to get an unconstitutional decision to overturn that law, and it didn't work. And actually, if you read a little bit more about Clase, you will find out that it was an experiment. Mr. Clase was paid to do this because they wanted to start the judicial engine to remove those type of state laws in red states, such as Louisiana. Yes? Didn't work out. It worked out the other way around. They got as I said, a discriminative precedent. Are we clear? Next, please. Check out the question above. Is it possible to overturn precedents? Move the clock to 1953. 60 years plus, isn't it? From 1890 something, now you move to 1953. All those years, the separate but equal doctrine remained, but this was a new era, right? This was, and then again, this is the very amazing thing about law. It shifts this as social matters shift. What was exactly the moment, the historical moment that was being lived in 1953? A war is ended, isn't it? Second World War. People wanted to change the perspective of the world, and then law begins to shift again. It's a social phenomenon. Which I know that we always hear about that in the initial courses of Introducción al Derecho. It's a living thing, is it? Like, oh, it's an alien. No, it's this. It really shifts in terms of the social moment, right? And this was a different moment as opposed to the ending of the 19th century. A new case came in to the Supreme Court. Brown versus Board of Education. Major case. Landmark case. The facts. In 1951, a lawsuit was filed in the U.S. District Court in Topeka, Kansas, another red state, by certain parents on behalf of their 20 children. The plaintiffs, people that felt damaged as a result of a certain regulation, demanded that the school district reverse its policy for racial segregation. That the school district reverse its policy of racial segregation. At the time, state law allowed the school districts to maintain separate elementary schools from Black and white students. Resembling what? Separate but equal. Isn't it? That's the same doctrine. Black kids there, white kids here. Following, this is Kansas, the other one was Louisiana. But it's the same legal doctrine. I hear some music here. Okay, sorry. So the matter escalated. It started out in district court and it escalated and ended up in the Supreme Court. The Supreme Court unanimously, which is rare sometimes, decided that racial discrimination in schools was unconstitutional, is unconstitutional. Since the Brown versus Board of Education ruling, the prohibition on racial segregation has become stare decisis, or binding precedent, on decisions of segregation and discrimination in all things. Every single case of racial discrimination that reaches the court has to be tainted some way with Brown versus Board. That's the stare decisis. Not only that one, there could be plenty, right? But the George Floyd case, you saw that all very sad findings, etc. All of that relies on that stare decisis matter. Answer: is it possible to overturn precedents? Yes. By whom? Whether the same court or the highest court. In case of the Supreme Court, only the Supreme Court then can overturn its own precedents based on what? On the political moment, the political history that is being in the country at particular reason, combination of many things. Are we clear in study insights?
Yes, sorry, for the Supreme Court to overturn precedents, is it necessary to have a unanimous decision or it can be simple majority?
Simple majority.
Right.
Simple majority. By the way, how many justices required to accept the case? 4. Only 4. I was referring to you to read New York Times every day. That's your task from now on. Every couple of weeks, there's a lady that writes, a journalist, a legal journalist that have been covering the Supreme Court for more than 30 years. Her name is Linda Greenhouse. It's an amazing source of information. Follow her. Linda Greenhouse. Every other major newspaper in the US has its own Linda Greenhouse, which are legal reporters following very stretchy legal developments in the country. And also follow the SCOTUS blog, Supreme Court of the United States blog. It's a more, let's say, relaxed way to learn about Supreme Court developments, cases, etc. Next. Okay. Based on our time, I know there's more material to be learned. We can perhaps devote some time on the next session that we're going to have, but it's 1 o'clock. I don't want to steal your time. So I know it's Saturday. So I think we can leave it up to now, unless you have any other question at this point. I think we can finish this first session. I really hope that you're taking something home. Try to, I don't know, put some thought to what we discussed today. And again, from a very relaxed academic way. And perhaps if you read something in the New York Times, let's see if some of the concepts that we studied today, like checks and balances, or the way the Supreme Court is configured, etc., can have a different stick now in your minds. See if it works. Okay, put it into practice. Thank you.
Bueno, pues agradezco a todas y todos por haber venido, los que pudieron venir ahora presencialmente, los que están ahorita por medio de Zoom también. Cordialmente bienvenidos a estar aquí presencialmente, o si lo quieren tomar de manera mixta o 100% virtual, también está muy bien. Gracias al licenciado Fabián por esta primera sesión. Les recordamos que son 4, el siguiente sábado, igual a la misma hora, al mismo canal, de 10 a 1 en este salón. Muchas gracias.